without further ado, we'd like to bring the audience straight into the conversation. And we'd like to start off with a poll. So any moment now, you'll see some questions before you on your screen. So please just take a few moments to vote on this, and then we'll launch straight into the discussions.
Isaiah, I believe we have our votes.
Yes, indeed. So we'll give it 5 more seconds. 4, 3, 2, 1. Okay. So interesting results. So the majority of our audience have not been involved in virtual hearings, haven't had the opportunity. And I sincerely hope that the discussions we'll have today will give you the information and the context you need that will help you. So first question I'd like to direct is to Mr. Shashere, if I may. These set of questions concern the regulatory framework for conducting a virtual hearing. So obviously the assessment of whether one can proceed with a virtual hearing depends on the applicable regulatory framework. And given the fact that most national laws are silent as to the conduct of remote hearings, do you think we need specific language in legislation or in arbitration rules to provide for them? Or is the current language sufficient to proceed? Mr. Shashere.
Yeah, I'm sure. Can you hear me?
Yes, please go ahead.
Yeah, thanks a lot, Isaiah. It's an interesting question, if I followed you, about regulatory framework for the whole virtual proceedings in arbitration. And I think if I have to start with a short answer, my answer would be a no. And the reason would be because, well, first of all, it's self-evident that many legislation is quiet at the point, and I think it's for good reason. Because if you look at how arbitration has developed, even from the common law related to arbitration, there's been a lot of emphasis on party autonomy. And party autonomy remains one of the features that have survived throughout both legislation and practice internationally and domestically. And that party autonomy gives the parties the right to shape how they want their proceedings to go by common consent. And I think that will allow for parties to agree and the tribunal to accept that consensus between the parties that there should be a rule towards a remote hearing and therefore virtual proceedings. And if we needed evidence for that, in Nigeria, for instance, in Section 2 of the Arbitration and Conciliation Act, you'll find that there's a strong reference to the right of parties, only the parties, to revoke an agreement once it's concluded. And therein lies, in essence, the power of the parties to conduct the proceedings. And there's further evidence of that sort of autonomy in the Arbitration Act of Lagos State, the Arbitration Law of Lagos State in 2009. And I want to spend a bit, just half a second on that point, because it reverberates across the industry. Because in that legislation, Section 1, it restates the general principles and objectives of arbitration and makes reference to a fair resolution by an independent tribunal, adhering to the necessity for no unnecessary delays and expense. And that gives the tribunal the sort of authority to follow the parties in deciding how to conduct proceedings. The good thing, as you know, Isaiah, that the proposed reforms to the Arbitration and Conciliation Act, which we are hoping will become an act soon, it's a bill in the National Assembly, I think 2019 bill, has exactly that same provision to refer to those overarching objectives of arbitration. And one of those objectives is party autonomy. And also the good thing is that many of the institutions have echoed this. So if you go to the institution, one of my favorite guidelines is the Chartered Institute of Arbitrators that also states as a guideline this same authority amongst the parties to insist on how they would like proceedings to be conducted. So domestically, and I would wager to say internationally, once the parties are able to say that they have agreed, and the tribunal can stick their objective and their duty to ensure that there is an efficient and a dispatch way of deciding the arbitration and conducting the proceedings, there wouldn't be any need for legislative change. And to seek to try and go back to the National Assembly to accommodate this innovation. And that's one of the things arbitration history has been known for, is innovation and creativity. So I hope I didn't ramble too much.
No, not at all. Interesting views. I'd like to get a civil law perspective as well. So Elizabeth, if I can come to you with the same question, do you think legislation needs to provide specifically for this, or is the current language sufficient?
Thank you, Isaiah. Good afternoon, everyone. So as a starting point, I agree that most arbitration laws are silent, as you stated in your question, Isaiah. Some are not. There are exceptions. So, for example, the Dutch Civil Procedure Code specifically allows the arbitral tribunal to resort to electronic means instead of personal appearance of a witness or an expert or party. So obviously, if you have that sort of explicit allowance, there can be no question. But again, as you said in your question, most are silent. So that's the case of France. In France, the arbitration law is silent on the possibility of a virtual hearing, but of course, it broadly entrusts the organization of the arbitral proceeding to the tribunal, who can make its decision either directly or by reference to arbitration rules or procedural rules. So in the presence of that sort of broad provision, is that going to be enough? I think it likely often will be, but you have to make sure that a number of things are in order. And one of those is of course going to be what the arbitration rules say. So that's going to be another very important consideration. And there again, some of the rules do specifically allow for virtual hearings. The LCIA rules, for example, specifically say that a hearing may take place by video or telephone, conference, or in person, or a combination of the three. The ICC rules, on the other hand, have been cited as an example of rules that make explicit reference to an in-person hearing. But even there, the ICC's note that was circulated in April in the context of COVID makes clear that in certain circumstances, the reference to the requirement of an in-person hearing when one of the parties requests it can, in appropriate circumstances, be interpreted as simply meaning that the parties have to be heard together in an adversarial way, but that doesn't necessarily mean physically in the same room. And they got there by looking at the previous rule, which says that the tribunal can allow all appropriate means to establish the facts, and also by looking at the French version of the same rule in the ICC rules, which doesn't use the word in person, but instead uses the word contradictoire, which simply means that there has to be an adversarial debate. So even on rules where you have a reference to an in-person hearing, that can sometimes be interpreted in a more flexible way. So again, you have to sort of look at all of the circumstances where you have this legislative void, which is the case in most circumstances. And you can also get clues from other provisions of the rules. So for example, where there are very strong provisions on the tribunal's inherent authority, that will give more of an opening for a virtual hearing. If on the other hand, for example, as you have in the 1976 UNCITRAL rules, you have a reference to a full opportunity to hear the case, well, that might be more of an indication that there could be some danger if the tribunal allows a virtual hearing and a party turns around later on and says, well, I didn't have that full opportunity to present my case. In the 2010 Al-Nusra trial rules, for example, that's no longer there. You have reasonable opportunity. So to give a personal anecdote, in the lead up to a virtual hearing that I have next week, one of the parties asked that in the protocol, it be stated that neither party will seek to set aside the subsequent award on the basis of the fact that the hearing was virtual. And the other party agreed to that provision, but with the caveat that it was not only on that basis. So if something goes wrong at the hearing, the party still wants to reserve the right to be able to try set aside on that basis, but they've committed to not trying to set it aside on the basis that it's only on the basis that it's virtual. Thanks.
Elizabeth, thank you very much. And incidentally, the Nigerian Arbitration and Conciliation Act has that language of giving the parties a full opportunity. So I suspect this is a conversation that will go on beyond this platform. But let me hand over to Kemi to introduce the next set of questions.
Okay, so our next set of questions relates with something that I'm sure everybody is concerned about. What if one party decides that they don't want to go on with virtual hearing? What happens? So I'll be asking Samar and Sheila this question. The principle that the tribunal should abide by parties' agreements on procedural issues is enshrined in many national laws and institutional rules. Nevertheless, can the tribunal proceed remotely where one party requests a remote hearing, but the other party opposes the request and insists on a physical hearing? So Sheilayo and Samar, we'll go with Samar first and then Sheilayo.
Thank you very much. Firstly, thank you to the Nigerian Bar Association and to the organizers of the conference for having me. I feel very lucky that we have platforms like the one we're using today that allow me to participate from New York in this event with all of you. So just to sum up on what we've heard, because everything that's already been said by Elizabeth and by Mr. Cheshire is really a lead up to the next question that we've just been asked. Just a couple of things I would add to what's already been said on scenarios where the parties agreed to have a virtual hearing, and Elizabeth alluded to that. You may have seen in a number of protocols that have been put out there, including one that I was responsible for preparing, and with a number of my colleagues at Hogan Lovells, the Hogan Lovells protocol on virtual hearings. And also you may have seen it in the protocol that the Africa Arbitration Academy recently put together. And I'm referring to Annex 3 of the African Arbitration Academy protocol, and also section 2.10 of the Hogan Lovells protocol. It's been suggested to try to avoid or minimize, because I don't think you can avoid, but minimize the risk of set aside, that parties try to the extent possible to enter into agreements pursuant to which they would not challenge an award if the hearing were to proceed virtually. And I invite everyone to review the language there. And as I said, I'm not sure that there's really a way to protect against set aside completely, but it is a sure way of protecting further. And I have been an arbitrator in a case before COVID-19 where such an agreement was used and agreed upon between the parties. Now, switching to the scenario, unfortunate scenario, I would add, where parties may not all agree on having a virtual hearing, what do? Well, of course, it's already been said, one should look at the relevant arbitration law of the Lex Arbitri. And as has already been said, there are none really, as far as I'm aware, that either impose or prohibit the use of virtual or remote hearings. So they're not often quite helpful in that regard. Although I would note, for instance, on the Nigeria Arbitration and Conciliation Act, that section 16.2 has been referred to, at least in some publications that I've seen, as being permissive potentially on virtual hearings, and I speak, of course, under the control of my Nigerian colleagues. Section 16.2 says that the arbitral tribunal may meet at any place it considers appropriate for hearing witnesses, experts, or the parties, or for the inspection of documents, goods, or other property. So query whether that can be used as permitting the remote hearings. Now, we've also covered the arbitration rules, and Elizabeth talked to us about some of the rules and what they say in that regard. And I will also add, in the legal landscape, one also has to look, of course, at the arbitration agreement. And I say that because very recently, I was in a position of arguing that the language used in an arbitration agreement, in a case in which I'm counsel, does not authorize or support a remote hearing. And I won't tell you the specifics of what my agreement says, but there are arbitration agreements that, for instance, provide language such as the arbitration hearing shall take place at such and such location, or at for instance, the ICC headquarters in Paris. And if the arbitration agreement has that language, then I think there is at least a colorable argument that that remote hearings may not be permitted. Now, once one has looked at the universe and the legal framework applicable, then really that leaves us, and there is no conclusive answer as to whether virtual hearings are permitted or not, or is there sufficient silence to then leave discretion to the tribunal to make that decision. Then I think that the arbitral tribunal should and has the discretion to consider the matter and to consider whether proceeding with a virtual hearing without at least one party's consent is appropriate. They should do so, of course, very carefully and by considering a number of factors, including, and this is not an exhaustive list, questions such as, what are the reasons for the virtual hearing request? Are these valid reasons? What measures have been taken to try and have a physical hearing? Or having a physical hearing simply impossible under the circumstances? Another question which I consider to be critical is, what is the content of such hearing? Is it going to be primarily legal argument, or will there be extensive evidence being taken, factual evidence and expert evidence? And I submit to you, then when it is the latter, meaning a lot of evidence is going to be given, then more attention should be given to the question of whether a remote hearing is appropriate. Of course, another criteria is, what is the delay if there is no online hearing? Are we looking at a potentially substantial delay? That is, of course, a critical question that we ask ourselves today, given the COVID-19 situation and the uncertainty as to when and how we will be able to resume normal activities. Ultimately, I think what the tribunal would have to do in this situation is balance, on one hand, its duty to conduct the arbitration expeditiously and efficiently, and on the other hand, the parties' right to equal treatment and their right to be heard. And I will add on that point that the right to be heard potentially is not infringed, assuming a situation where the hearing is fully remote, in the sense of course, you would have a more complicated situation at hand if one party were able to attend in person where the other were not. So the equality of where the parties are situated, and of course, their access to technology and their level of familiarity with it are critical points that need to be examined by a tribunal. So ultimately, the tribunal's job is to evaluate these issues carefully, to evaluate the duty to conduct expeditiously given the circumstances, and it will remain to be seen whether challenges will be filed simply and solely on the basis that hearings were conducted remotely. As I sit today, I am not aware of any court decisions in any jurisdiction setting aside an award solely on the basis that a hearing was conducted virtually.
Thank you, Samar. So we'd like to hear from Sheila now. Considering the climate we're in and our environment, what are your thoughts?
Thank you, Kemi, and good afternoon to the audience. Thank you very much, Samar, for the references you've made. You literally covered as much of the issues as we need to cover. I will go a little bit to the specifics. For example, I mean, we all want a situation where parties can have an agreement to virtual hearings. But for reasons, many reasons that parties have, either because a party chooses, we have a recalcitrant party, or because some parties are just not comfortable with the process, they might be pussyfooting as regards having an agreement. So we will likely face situations where one party wants to go the way of a virtual hearing while the other does not want to go there. So Samar has made very valid points as to the considerations that the tribunal has to make. Now, in the absence of specific legislation that excludes virtual hearings, and as we've said here, there aren't any, at least that I know of, that specifically exclude virtual hearings, then the tribunal would look at the lex arbitrary and determine from the lex arbitrary whether or how to proceed. Now, in most model law jurisdictions, especially those that have adopted Articles 18, 19, and 20, the language is fluid enough to accommodate virtual hearings, because to start with, for example, if you take our section 14 of the Arbitration Act in Nigeria, it says, yes, a full hearing, parties will be accorded equal treatment, but it goes on to say that where the parties are unable to agree, and also where the rules that are chosen by the parties is silent, then the tribunal has default powers. And I guess that's where the questions that Samar has put forward for the tribunal to consider become very relevant, because clearly in the absence of an agreement, it's not going to be a walk in the park for the tribunal. So you need to really determine whether in the particular case at hand, it is the step that ought to be taken. Now, where you have, and I believe, for example, under the Arbitration and Conciliation Act in Nigeria, virtual hearings are allowed. The question then is as to the considerations that we'll make. What are the limitations, if any? The first which you typically think about is what I just said, section 14, that talks about equal treatment. Then also you have section 15.2, which talks about the right to fair hearing. And I mean, if I could make a point about fair hearing, which Samar has touched a bit on, we often make a mistake. A lot of people run into the error of thinking fair hearing means that we must be heard. Fair hearing is about the party being afforded an opportunity to be heard. So if the tribunal has to make a determination at that point as to whether the whole or part of the proceedings should go virtual, all the tribunal needs to think about is the right to fair hearing and equal treatment. We shouldn't also forget that the law permits a default hearing. So a situation where a party decides that he's not going to participate, there is an obligation on the tribunal to proceed. Well, not an obligation, but the tribunal can proceed, but with the caveat that it must not treat the refusal to participate as an admission of the case at hand. If you look at the language of the Arbitration Act, which is really an adaptation of the Uncial Model Law, particularly section 52, it talks about the powers to deal with any matter related or to or connected with any particular arbitration. So the tribunal has default powers in that sense to proceed. Now, the other comment I'd like to make is that regarding the virtual hearing thing, I think it's a universal concept about fair hearing that it's not a must that the tribunal will hear you as long as you're afforded an opportunity. Now, while preparing for this, I went through the UNCITRAL notes, the digest of the 2012 digest of the of UNCITRAL, on case law digest of UNCITRAL on the model law 2006. And I was pleased to find that even as far as other claims, not just in Nigeria, even in Canada, there is a decision where a party refused to participate. Now, it wasn't a virtual hearing to the best of my knowledge, but refused to participate after starting a while. And the court refused to set aside the award on that ground. So I think it's safe to say the simple answer to that is the tribunal can proceed, of course, subject always to the lex arbitri. The only other thing I should add is in regard to venue, which Samar referred to. In this sense, I mean, you have to view what venue is in the context of what we have today. And if you look at some of the protocols in question, particularly if you look at the Seoul Protocol on video conferencing in international arbitration, it actually gives a very fluid definition as to what venue would be. And that includes not only where the arbitrators are seated, but also the place where the remote hearing is taking place. I mean, at the end of the day, it's a contradiction in terms to say that a process that is renowned for flexibility will now not admit of a tool that allows for that flexibility to be in place. So my straight up answer to that is yes, the tribunal can proceed. And yes, we have in our laws, especially those that have adopted the UNCITRAL model law, yes, they can proceed under that as well. If you look at, I've been able to come across some rules where those provisions of UNCITRAL model law have been interpreted to mean that the tribunal can have virtual hearings. One of such is the Korean Commercial Arbitration Board rules of 2016, which talks about that as well. Thank you.
Thank you very much, Samar and Sheilayo. Over to you, Isaiah.
Thank you very much, Sheilayo. Thank you and Samar also for your very succinct comments. Now, next question is a very interesting one. Paints a scenario. And as you read this, I'd like to reassure you that arbitrator Gross in this scenario is not Elizabeth Oja Gross. But let me read this scenario and ask Elizabeth the question. So in proceedings challenge a FINRA award, the petition alleges that the panel was inattentive with arbitrator Joel Finnard looking at other screens, typing and eating during the course of the presentation. It also alleges that arbitrator Jill Gross even blocked her screen during the hearing, preventing the parties from confirming that she was even participating. And at one point during closing arguments for WSI and Mr. Wunderlich, Chairman Renee Hoyler walked away from the screen. So Elizabeth, in your opinion, can a distracted or disinterested tribunal in virtual proceedings form the legitimate basis to challenge an award?
Thank you, Isaiah. This is an interesting question because it's very specific to virtual hearings, and yet it's very universal at the same time. We have all had in physical hearings situations in which we are less than pleased with how much attention the arbitrators are affording us, right? We are all excited and have been preparing for weeks and weeks to give our stupendously interesting arguments and our stupendously interesting cross-examination, and the arbitrators don't seem as excited. Perhaps their eyes are closing. If they're not closing, they're glazing over. Perhaps they're looking at their phone. So this is a situation that we're all familiar with. But of course, we have the specificities of screens. So it's true that in physical hearings, you generally don't get arbitrators eating. They don't stand up and walk away, and they don't block themselves so that you can't be certain if they're there. But nonetheless, it's just a different degree of the same issue, I would say, right? So the question then is, do you have many situations where you have awards that are challenged on this basis of inattentive arbitrators, and what happens with them? I looked for some in preparation for today, and I didn't find very many. I found one, which is from a 2014 New York District Court, Southern District of New York, where a party contended that an arbitrator had engaged in misbehavior by not informing the tribunal that he had a brain tumor. And that brain tumor apparently had caused him to not be very attentive, to not be giving his all to in terms of attention to this hearing. And the district court, in response to this challenge, said, many matters such as brain tumors, substance issues, marital problems, lack of sleep may affect an arbitrator's concentration, but under the Federal Arbitration Act, parties are entitled to unbiased and uncorrupted arbitrators, not perfect arbitrators. So I think that encapsulates nicely the problems with trying to challenge awards on this basis. You're not entitled to perfect arbitrators. You're entitled to arbitrators who are not biased against you, right? So in order to make this challenge, you would probably need to try and fit this, these not very nice behaviors into an existing ground on which to challenge an award, which would be inequality of the parties, due process, etc. So I guess you could say that if you could show, for example, that one of these arbitrators was engaging in this behavior only when one party was speaking, for example, I don't know, you have, for example, a recording of these proceedings, and you can show that, that could perhaps work. Or something that shows that the party wasn't able to present its case in a way that really caused it harm in terms of the equality of arms between the parties. But otherwise, even though this behavior is pretty egregious, it seems likely to affect the ability to challenge the award. Again, you can always try. But what it will, of course, affect is the arbitrator's reputation, and that's where, like in regular hearings, the sanction will generally come.
Elizabeth, thank you. Before I hand over to Kemi, we are noticing the questions in the Q&A section. Thank you very much for asking them. I can tell you that some of these questions are coming up, and the ones that we don't address, if we have time, we will put those to the panelists. So thank you. I'm also noticing attendees putting their hands up. If you have a specific question, please ask it in the Q&A section, and we'll do our best to attend to that. So Kemi, over to you for the next set of questions.
Thank you, Isaiah. So my next question goes to Mr. Shashere, and it has to do with an E award. With what has happened, it is clear that there can be a time when we can't move around for whatever reason. It has become evident that it is possible to have a lockdown where you can't step out of your house. So you have an award that is time bound and has to be signed and all of that. In your view, Mr. Shashere, how do you think the tribunal should go about it? Do you foresee a situation where we begin to have E awards?
Thank you very much, Kemi. I think the necessary outflow of the procedural adoption of virtual hearings and the need for parties, as you tried to describe it, being in different places, the tribunal members being in different places. We've all experienced, particularly in international arbitration, where you've had to have either a preliminary meeting or some part of the proceedings where either the tribunal members or counsel are in different places. And the necessary result of this sort of innovation would be that you get signatures coming from different parties at different times. even though they may be physical signatures and there'll be exchanges in counterparts. But you'll get situations where people might be looking to provide an e-signature. So it is very likely and possible. But if I could just reflect on what Elizabeth said about the distraction of an arbitrator very quickly. It's very interesting because it's more often than not that connection will be lost. And I think we'll probably deal with this later on in the proceedings. And I found it interesting that it isn't just the fact that you lost connection, and therefore the whole idea of an inattentive arbitrator isn't of itself a ground for rejecting an award of misconduct. You would have to look at the quality of how much that misconduct relates to the award. And in the case of a sleeping arbitrator, for instance, you know, the city Galway situation Galway City situation where it was decided that the mere fact of his sleeping off and dropping off wasn't in and of itself enough to set aside. It's a very interesting point. But to go back to e-awards, I think you will find it's likely to happen with more use that arbitration proceedings make of virtual proceedings. I don't see anything in the Arbitration and Conciliation Act that bars an electronic signature on an award in and of itself. Section 26 and the rest of them don't say that the awards will bar an e-signature. And it would be safe enough to say that if the parties agree and the tribunals have warned parties in advance and the parties have agreed, that would be sufficient. But it's enough to warn arbitrators and the parties that several jurisdictions deal with enforcement in different ways. And if your award is to be enforced in a place like Nigeria and several other jurisdictions where you may require a physical document, and that physical document needs to be cited, authenticated, and certified, an e-award or some sort of electronic representation of the award of the tribunal might not be sufficient, and it might fall short of the internal procedural requirements of the enforcing country. So I think it's enough to caution practitioners and even the council and parties that yes, there will be e-awards, but a regime will have to mature in order to accommodate it. And as we stand, many of the enforcement proceedings, Section 31 of the ACA is a case in point, which borrows from the New York Convention, and convention countries are in the majority still. You will find that authentication, originality, and in many circumstances, certification of the award is required, which on the face of it, an e-award wouldn't qualify.
Thank you very much indeed. And you'd be interested to know that the Vienna International Arbitration Center is actually implementing this in cases where the arbitrators, the award can't be sent to the respective arbitrators for their physical signatures. They're now allowing e-signatures pending such time as a physical award can be delivered to the parties. But let's move on, given time, to the next set of questions. And this is one that's very interesting, and I can see there's a question on this in the Q&A. Samar, let me come to you. The question of witness tampering, it raises a real problem concerning virtual hearings. Now, in your experience, what can the tribunal or the parties do to mitigate the risk of witness coaching in virtual proceedings?
Thank you very much, Isaiah. And please allow me, and I promise you it will be extremely brief, to comment on the earlier two questions. On the sleeping arbitrator point, I will simply say that if a sleeping arbitrator were added as a ground for set aside in Article 5 of the New York Convention, over 50% of awards would likely be set aside.
Absolutely.
So now, joking aside, on the very interesting e-signature question, I simply want to say I come from Egypt, which, like many jurisdictions in Africa, is very formalistic, and also in the Middle East, as I think you all know, these tend to be very formalistic jurisdictions. And in fact, in the UAE, up until the recent new arbitration law that was enacted a couple of years ago, and I've sat as arbitrator in a number of Dubai seated arbitrations, one had to physically travel to Dubai to sign the award. So it wasn't even just a question of wet ink signature, but you even had to be present in the place of arbitration to sign the award. So it will be interesting to see how these formalistic jurisdictions deal with these e-signature issues, indeed. Now, to answer your question about witness tampering, I will start by saying that this issue has always been around. It's not specific to virtual hearings. It just is rendered, unfortunately, more complex through virtual hearings. But we've all been in hearings where the tribunal members will remind any testifying witness before a break is taken, for example, that they are not to discuss their testimony with anybody until such time as they are done giving evidence. Now, in the context of virtual hearings, things are more complicated because you cannot see the entire environment of where these witnesses are and what kind of coaching or what kind of help they're getting. This can be, I think, addressed in the following ways. Firstly, before the hearing, during the pre-hearing conference, I think it is incumbent upon the arbitral tribunal to remind the parties and the counsel that no witnesses should be allowed to confer with counsel or with any party representatives while they are giving evidence. And they should also clarify that only authorized people should be in the room. And what I mean by authorized people are, of course, any members of counsel team, for instance, if it's not a fully virtual hearing, that ought to be present in that room, or a designated individual that may be a technical assistant who's going to be helping the witness, for instance, going over exhibits, documents as they are being referred to. But that in any event, those individuals should be announced and only the authorized individuals should be in the room. Now, during the hearing itself, I would say that at a minimum, the tribunal should confirm at the start of the hearing or the examination that the witness is not receiving any communications or assistance of any sort from any unauthorized person during the testimony. And again, they should be asked to identify anyone present in the room with them. So that process, I think, will serve to provide some level of security around the giving of evidence by the witness. I think that process should be repeated after each break. And then, as you may have seen in a number of the protocols out there, including in the Hogan-Lovells protocol at section 3.3, we have suggested that potentially witnesses could be, when they're, if required to give oath, which of course is sometimes the case depending on the relevant applicable laws, that oath be expanded at the outset of their testimony to say that there is no one else in the room, and I'm reading from the Hogan-Lovells protocol, there is no one else in the room with me except authorized attendees, that no unauthorized parties can communicate with me, and that I am not currently aware of what documents will be shown to me by opposing counsel, which is an added issue that I think one should keep in mind in scenarios where documents are sent or shipped to the location where the witness is testifying from, assuming hard copy documents are being used, and to ensure that these documents had not been reviewed prior, for instance, to the cross-examination. Now, it's been also suggested by some commentators that the witness should be, that the entire room should be visible, that a camera should be used to show the room, to show that no one's in the room. I'm not sure that I agree with that, in the sense that there is really ultimately no way of ensuring that the room in its entirety is visible at all times, and that people can't come in and out. So I question the limits of this exercise. But I do think that if the steps that I've outlined are taken, that should provide a reasonable amount of security around the issue and of witness tampering and assistance to witnesses. Thank you.
Many thanks indeed. So let me hand over to Kemi for the next set of questions.
Thank you very much. So my question will go to Sheilayo, and I'll be asking about your views on security breaches during the tribunal hearing, and how do you think this can be mitigated? I know you are not an IT expert, but from your opinion, how do you think we can mitigate any such intrusion during the hearing? Very briefly, thank you.
Thanks for the reminder that I'm not an IT expert. I was a bit worried when I heard security breaches, and I'm thinking, all right, do I have to start thinking about hackers at the moment? So here it is. For me, there are two sides to this issue. There is what Kemi just alluded to, that which is more technical, where you have hackers coming in and how do you prevent them? That is way beyond our remit as arbitration practitioners. Maybe if it's an arbitration that involves the computer geeks and the hackers themselves, they might have certain other protocols that will work for them. But for us, there is only so much that we can do. But that said, I mean, you have, I mean, again, building up to this webinar, I stumbled on a case concerning the Philippines and China. I think there was a marine border dispute where the website of the Permanent Court of Arbitration was hacked. The website of the Department of Justice of the Philippines was also hacked. So even if at that level you can have hacking go on, I don't see how you can prevent it. And hackers tend to reinvent themselves. So I think you just have to focus on the dispute you have, look at the platform you have, and determine the suitability of the platform that you have. So the first thing I would say regarding that is check on the platforms. There are different platforms out there. There is WebEx, there is Microsoft Teams, there is Zoom, which we're using now. There's GoToMeeting, there's Google Meetings. There are all sorts of applications out there. Now, make sure that whichever one you're going to select has built-in levels of security. So for example, we have the Zoom meeting platform, which has a waiting room. We introduce passwords. You make sure that is there. And there are protocols also that have helped in that area. In this regard, the Africa Arbitration Academy protocol is quite instructive, not least because it is specific to Africa. And so we'll deal with it. It tries to address some of the challenges and provides what you should consider the barest minimum standard that you'll need to keep as far as those issues are concerned. Now, moving on, of course, there's also the SOAP protocol. Now, moving on to that which is within the ambit of our control, and that is now protecting or safeguarding the integrity of the process, dealing with things like intrusions by third parties into the hearing rooms and all that. Again, these virtual hearings, and we're here using Zoom, what they do, they try to replicate what you have in your normal physical hearing session. So like I just said, Zoom has a feature, you have the breakout rooms, which for a tribunal, witnesses out of court and out of hearing, you can get people out of the place. You have the passwords and all that. Now, one thing that I feel is important is that there must be some element of central control. Now, Samar referred to the need to have a technical person. I mean, it all depends on the kind of arbitration you're dealing with and how complex it is. But for your basic arbitration, your registrar might just serve the purpose. One who is very, very familiar with the features of the platform. We're having this seminar, there is someone in the back room who is controlling everything. There is a host and there is a co-host. So somebody must be there to be able to control and make sure that certain things do not occur. Now, it is important that everyone, the arbitrators and the parties, familiarize themselves with the features on the platform. They familiarize themselves with the features of the platform. And while on that subject also, we must note that only the relevant people must be allowed in the room. Now, I say these two things because of a recent experience that I had in just a preliminary meeting session. Now, we had a situation where some fellow just came into the room. We didn't know, well, he occupied the device, he took over the device that was being used by the party representative. And 5 minutes before the meeting, the party representative left, and then he took over 5 minutes before the meeting started. When the meeting started, I asked, who are you? He was muted, the video was on. I kept asking, who are you? Can you please introduce yourself? Can you please introduce yourself? We could see him, he could hear me, or at least so I thought, but he didn't respond. On the flip side was the counsel, who I then asked, could you do an introduction of those appearing with you? And counsel said, oh, I could only see the arbitrator, I can't see any other person. Then I tried to explain, saying that, look, if you look at the Zoom features, it has an icon there that you tap and will give you the grid view. Now, he said, no, I don't have that on my phone. So this speaks to the need for everyone using the platform to familiarize themselves with the process, and then also to ensure that that person who is the unknown third party becomes known. Now, in that meeting, when it became difficult and it could not be identified, it was his counsel that I said I should remove him. So I had to remove him. Everyone that participates in every session must be relevant to the proceedings. Everyone there must be relevant. So if you're going to have somebody who is neither party, nor witness, nor counsel, nor arbitrator, nor registrar, then that person must have a reason for being there. It's your typical situation where even your registrar doesn't just come in because he's with the tribunal. The tribunal still requires the consent of the parties for him or her to act in that role as a registrar. Now, another thing is that we should do trial runs. Always have a trial run of this platform, and in course of doing the trial run, typically you become familiar with the features of the platform. It is very important. Now, the SOL protocol on video conferencing recommends that you should have at least 2. 1 weeks before, and the other a few days before the hearing. Now, these are the things that you need to do. Now, of course, there are 2 more things that just occurred to me. The first is that if you're going to give everyone who's going to have access to the platform a key or a password, you must introduce levels of security that say, look, do not share this. Some of us got the invite for this webinar, and it says clearly, this link is peculiar to you. Do not share it with anybody. And we must know that that is very relevant. And then as far as recording is concerned, we must ensure that no recording is done except with the consent of the tribunal. Now, that's all I can say for now. That, like I said, there is only so much that we can control, but it's important that we start from the choice of the platform and make sure that we're familiar with the process. Also, the tribunal must ensure that everyone in the room is sensitized, is aware of everyone in the room is relevant to the process. Thank you.
Shailaya, thank you very much as always. Now, question of time zones is a very interesting one. Samar made the point that she's dialing in from New York, so I think this is an appropriate question to her. I'll ask these 2 questions in one, actually. I'll direct the first one to Samar and the second one to Elizabeth. So, Samar, how should the tribunal determine which time zone governs the proceedings, where you have parties in far-flung areas in the world. And Elizabeth, if you have a wide time gap between the parties, would the party with the inevitable late shift have a legitimate argument that you didn't treat me fairly? I was disadvantaged in the presentation of my case. So Samar first, then Elizabeth.
Thank you very much, Isaiah. It is indeed a question that I am painfully familiar with at present. I have been in the process of preparing for a virtual merits hearing that is going to be happening next month, in which my client is based in China. And that means 12-hour time difference with New York, where I'm based, while some tribunal members are sitting in San Francisco and others are in London. So I leave it to you to imagine the complexities associated with finding good time zones for all concerned. The answer is it's impossible, which leads precisely to the question that you asked. And I have actually strong feelings about it, and some of which are against my personal interest, in the sense that, of course, while I would ideally like to be in the prime time as either a defending or questioning or arguing lawyer in these proceedings, I do strongly believe that the primary beneficiaries of the prime time should be, without question, the testifying witnesses. And that is because they have less familiarity, and I'm speaking particularly about fact witnesses, but also expert witnesses to some extent. They have the least familiarity with arbitration proceedings. They are potentially the ones being put under fire in a potentially difficult cross-examination. So it is only fair to afford them the best possible treatment and to allow them to testify at reasonable business hours. That is precisely what the tribunal in my case has decided to do, meaning that they have made provisions for the witnesses to testify during business hours, so roughly in the 9 a.m. to 5 p.m. time frame, wherever they are located, and everyone else is going to have to deal with that, as difficult as it might be for them and in the specific time zone that they are in. The tribunal in that particular case said, even if that means for them sitting at wee hours of the night, they are prepared to do so, which of course is appreciated by all concerned. So in my opinion, there's no static answer to this question. It certainly shouldn't be, well, we should go with the time at the place of arbitration, or we should go with the time at some other place. I do think that considerations of fairness to the witnesses who are testifying should absolutely be the primary guide for that. And then secondarily, when no witnesses are testifying, one should of course try to accommodate as much as possible all participants, which means potentially starting very early. In my case, for example, being in the East Coast of the US, or in the evening time, whatever the case may be, with due regard to all participants.
Elizabeth?
Yes, thank you. Like Sama, I'm going to start off with a couple of war stories, as you will. So in one case where one of the parties wanted to go ahead with a virtual hearing and the other was resisting, the party resisting made this argument that it couldn't possibly, that everyone involved in this hearing is not going to be able to properly adapt to hearing hours that are not the normal business hours, and made the comment that the body clock, in fact, won't even be able to adapt. But in deciding to go forward, the tribunal basically said, I recognize these issues, but they're not insurmountable. Let's all be reasonable and try and figure out a way. And I agree entirely with Sama that a pragmatic approach to these things is definitely the way to go. The second example is for an upcoming hearing I have where it's a less extreme situation than the one Sama described, because we're not spread from San Francisco all the way around the world to China, but just from the middle of the United States through to Paris, which is the most advanced time zone. And it's been decided in a relatively cooperative process that the hearing day will start at 7 a.m. for those in the middle of the United States, so 2 p.m. for us, and then it will go through until 9 p.m. our time, which is 2 p.m. their time. So they start uncommonly early, we go uncommonly late, but there's nothing extreme. No one is questioning an expert at 3 o'clock in the morning. So that's how it should work. And I think in that situation, to come to the question that you've asked me, there could not really be any legitimate argument that anybody is disadvantaged by having to go a little late, having to start a little early. In these sorts of situations, I think everybody's in the same boat of trying to adapt in a practical, common sense way to the new circumstances. And I think that's really coherent with the kinds of before we had virtual hearings, the kinds of circumstances in which tribunals looking at set-aside requests, for example, have said this is not the kind of disadvantage that would cause a party to be able to set aside an award, because there seems to be almost, in most jurisdictions, there seems to be an understanding that you have to have a really big disadvantage, a really big inequality to not be able, to be able to set aside or challenge an award. So it's not if you have a week extra to put in your memorial as compared to the other side. It's if you have 3 months extra to put in your memorial as compared to the other side, or similarly, if one side is that the tribunal says you have to do your brief in 50 pages and the other side has 200, yes, of course, that's a breach of equality of the parties, but not these sort of we're trying to work things out kind of decisions that tribunals make on a daily basis, because perfect equality, of course, is illusory in an imperfect world. So I think that's generally going to be the answer, but as with everything, it's fact specific. And perhaps if you had a particularly unreasonable tribunal that when you look at the entirety of the circumstances seems to be making every decision in favor of one party and not in favor of the other, that perhaps you could try and say that you were disadvantaged, but as with all of these questions, it would have to be a pretty extreme case.
Elizabeth, thank you very much. Kemi?
Thank you, Elizabeth. So I'll go now to Mr. Shashere, and my question is, what would a tribunal do if it realizes that a party has unstable connection or just drops off for whatever reason, technical reasons, and is unable to reconnect? What should the tribunal do? Mr. Shashere.
Or indeed any of the other.
Okay, any of the panelists can take this question, please.
Mr. Shashere.
Okay, he's online now. Thank you.
Yeah, I think I'm being controlled by the host. Yeah, I mean, the question is double barreled. It's whether the arbitrator, it's when the arbitrator or the party loses connection. And I think they have different implications, probably about the same result. Where a party loses connection, is unable to rejoin, this is presuming that you've gone through your sole protocol, you've tested, and matched everybody's technology, you've chosen the lowest common denominator, and you found that everybody is on an equal and even keel. And yet something happens and this party can't participate. Now, you know, these same overarching principles that I referred to earlier on, equal treatment, will only dictate that, you know, the tribunal is best advised to ensure that the parties have an opportunity to be at the proceedings because of the requirement of a fair and impartial treatment, and equal treatment. And Section 30 of our national law is very clear on the consequence of failing to do that, because it could result in a whole hash of that entire body of law called misconduct. And you know, it's still part of our law, part of our statutory law. It's always part of the common law. And it's important that arbitrators remember that if that happens and the parties are unable to rejoin, and that was your question, it's important that you ensure that there is a party representative and is present as well. Otherwise, the whole rash of ex parte proceedings and one-sided hearings will be brought in. So my answer would be, as far as the party is concerned, these proceedings should terminate and afford that opportunity to the party to participate. Otherwise, the proceedings could be vitiated. And my hope is that as our legislation progresses, the opening the door to misconduct, not in this area alone, will reduce. But if an arbitrator loses connectivity, and you've got a panel of arbitrators in 3 different places, and one of the arbitrators loses connectivity, again, you're faced with this inattentive, non-participating, almost sleeping arbitrator, and whether or not that's enough to affect the proceedings. So again, the tribunal would be well advised to ensure that these proceedings are of the nature that you require the attention of all members of the tribunal, and safety always determines that all members of the tribunal are present and attentive at all times. But it brings, you know, there's this little anecdote that I just want to introduce before we move on. I've been involved as counsel in a case where I felt that I wasn't afforded an opportunity to cross-examine a witness. One witness had died. The only other witness was not present at the proceedings. And the tribunal was robust enough to say, well, you had the opportunity, and they proceeded. And the award held, and that was an international arbitration, London arbitration. And on the other hand, I've been arbitrator in the domestic arbitration, in which I gave 3 opportunities to counsel to present his case, very mindful of the prospect of having the whole proceedings vitiated. And I think I've been better served by that sort of caution. And I think that's important to always bear in mind. That the tribunals, this is a practical situation. Tribunals, each case will differ from case to case. A tribunal should make sure that equal treatment is that cardinal compass that guides decisions in this situation. And where one party can't rejoin the proceedings, you need to make sure that that's important.
Thank you very much indeed. Well, we have 15 minutes left in this webinar. How time flies when you're having fun. So we have lots of more questions that have been submitted, but I think it's also important that we address some questions that have been submitted in the Q&A to bring the audience in. One of these questions actually overlaps. The one asked by Mrs. Folashade Ali, that wouldn't a virtual hearing impede the proper assessment of a witness in determining the veracity of his testimony? So in other words, how do you translate your advocacy in a physical hearing to a virtual environment? Let's throw this one to Samad, and all the other panelists can chip in if they have any views.
Thank you, Isaiah. It's an excellent question. And you may recall in some of my earlier remarks regarding the various criteria to consider when deciding whether or not to proceed with a virtual hearing was precisely the question of how fact intensive is the case and how much evidence is going to be given. I happen to believe that yes, the impact of the evidence that is being given is not the same when you are sitting in a physical room and when you are giving evidence in front of a computer. And of course, I have been in situations as counsel where I have made that argument. In particular, in cases where, and I usually am, not always, was confident that my witness's credibility was going to win the day. And that I felt very strongly as a result that those witnesses should be heard in person. And there is just no substitute for that. And that is also one of the reasons I believe that while we're going to be seeing, no doubt, an increase in the number of virtual hearings as a result of COVID-19 and long after COVID-19, because we are now all much more used to and accustomed to using these platforms, I do not believe that there will simply be it's the end of physical hearings like some people have been saying, because I do think that sometimes there is no substitute for physical hearings, and for good reason. I don't really have the answer as to how do you then translate that into effective advocacy on your behalf, or how do you help your witness be more effective, other than to say, of course, use the technology as best you can to make sure that the witness has and is able to make eye contact with the questioning witness, but also ideally with the arbitrators. Good luck with that. And just hope for the best. But there is something that is lost in translation when a hearing happens virtually, and I don't have the magic answer to say how that can somehow be recouped, unfortunately. I hope that my other panelists do.
Would any of the other panelists like to share their views on this, perhaps? Otherwise, we can address another question submitted. I'll hand over to Kemi.
Okay, so this question is from Joe Chiari Gazama, and his question goes, what do you consider as the limitations of virtual hearing in construction arbitration, particularly where there is necessity to visit the locus or the construction site? So any of the panelists, feel free to answer this question, please. Can you hear me?
Kemi, I think we should put someone on the spot. So
okay, so
give in a situation where I think Samar may have already kind of answered this question in the sense that if the nature of the proceedings are not favorable or suitable for a virtual hearing, then it would be unwise to proceed. So I presume this would be one of those instances where a physical visit is required. Quite honestly, you couldn't deal with that in a virtual environment. One question I would ask as a follow-up to that is, how do teams, if you're in different locations, how do you build rapport with each other? How do you stay in communication with one another? How do you make tactical decisions in a virtual environment?
I'll jump in, and I'm sure others will have a lot to add on this, but I just wanted to suggest, Isaiah, if you don't mind, whether you could share an image that I sent you yesterday, and I see it's already there. Thank you very much. And before I say a word about it, I want to make sure that due credit is given to my dear friend Patricia Saiz, who is a professor at ESADE Law School in Spain, and who has prepared this image. And I thought maybe that would give all of us food for thought to answer the question you just asked. What you're looking at is essentially a setup for a full virtual hearing, and what would be an ideal situation in terms of hardware that would permit all the different chips to fall into place while the hearing is ongoing. From the webcam at the bottom of the main screen to view the participants and potentially to view documents, a separate laptop so that you could see live note, meaning the transcription live of the hearing, a mic, of course, a tablet that you can keep separate to see the electronic bundle of documents. And then, and that gets us to the answer to your question, Isaiah, the cell phone to keep in touch with your team members. I know that platforms like the one we're using now allow for separate chat rooms and the like. I am a skeptic, and I think we lawyers are by nature, and I would be a little bit concerned about, and it is because I have heard, by the way, that you can print a full transcript of private chats on Zoom that would show you not only the group general chats, but also the private chats. So it is a result in part of what I have heard on that, that I would be particularly careful about not necessarily using the same platform for private chats. And what I have been doing is using others like WhatsApp on a cell phone to communicate with my team. In fact, I had a case management conference last week in a London seated arbitration where all of the other team members were based in London. And we used WhatsApp to keep in touch, and we're giving each other ideas for ways in which we could address various questions posed by the tribunal, and it worked extremely well. But I'm sure my co-panelists have additional thoughts on that as well.
Thank you very much, Mar. Yes, Elizabeth, please go ahead.
I'd like to second the WhatsApp idea and add just that we already do this even when we're sitting in the same room, because of course, when you have one person speaking in a hearing, that person only has two sides, so that person can pass notes. But for big cases, you have 10 other people from your team in the room as well. And it's more difficult for that person, for those people to get access to the person speaking. So in a hearing I had last year, for example, we had a very big team and we had a WhatsApp group, and we were using that even sitting in the same room with each other because it works so well. So it would work just as well here, of course.
Elizabeth, thank you very much. Did any of the panelists want to make any additional comments?
Yes, Isaiah, I had wanted to make comment about building rapport earlier on before Samar came in with her response to the features. I think the question asked that touched on here by Mrs. Ali in particular, I think that goes to the issue of a tribunal building rapport. How do we do this? I think part of the things we need to do start from the things we agreed to on the protocol and directions that the tribunal gives. So again, I would refer the audience to the SOL protocol. I will refer the audience, I think, to the guidelines of the Chartered Institute of Arbitrators, which attempt to spell out certain things that I think will help build the rapport. For example, allow for a reasonable part of the interior to be visible. You want to create that impression that this person is in a place where he can, the person looking at him regards it as a hearing room, and he also can see you likewise. So let it have that look and feel. It applies to the witness as it is to the arbitrator too. The witness should testify with an empty desk. I mean, you want to be sure that there are no distractions so that he can communicate and look at the tribunal. And if at all there is anything he's going to be referred to, is probably in the bundle that he has. One thing that is key is the audio. The audio is very important. You must be able to hear one another speak and ask questions, avoid needless intrusions. And where perhaps any participant is in a venue that has difficulties in connection, then you also, as a tribunal, want to ensure you allow for time between questions, because there might be a delay in the communication. So, because the witness must be sure that, oh, he is being understood, just as the tribunal must be certain that the witness is hearing the questions put to the witness. I think these are all part of the things that we need to do. But then there isn't an exhaustive list. I believe that each will be taken on a case-by-case basis. I believe that everyone would need to sensitize themselves as to what to do as we go on in this new normal. Thank you.
Shaila, thank you very much. I'm looking at the time, and regrettably, we have literally 3 or 4 minutes left. And while we do still have very many other questions, those submitted beforehand and those submitted in the Q&A, we are not going to be able to address each of them. We sincerely apologize for that. What I can, well, not promise, what I can use my best endeavors to do would be to ask the panelists if they wouldn't mind putting their thoughts down for the remaining questions, and we'll be happy to share that with the audience as perhaps a Q&A that addresses the most common questions. And also this webinar is being recorded, so we will also make the recording of this webinar available on the SBL website. And with that said, I'll hand over to Kemi if she wishes to say anything in closing, and then invite Mrs. Akpata for the closing remarks.
Thank you, Isaiah. Well, I'll just like to say thank you. It's been an enlightening session. We have a lot of questions, and unfortunately, time would not permit. But like we said, we'll be in touch. However, just to wrap up, I have the thoughts on the panelists on what is the future of arbitration with all of this? Do you think virtual hearing will be embraced? I know we've touched on it a bit, but just like for a wrap up, what would you say? Or with what has happened now, I see more people being receptive to it, or I feel like a lot of people are going to object to it, or we're going to develop more standard protocols that would help us with it, and it will just become the next normal. So that's my question, and then I'll hand over to Mr. Akpata. Thank you very much.
Okay, can I jump in?
Please go ahead, sir.
Please go ahead.
Yeah, okay. Okay, right. I think there'll be an increase, and I'll be very, very brief because I know everybody's got to fit in. There'll be an increase in virtual proceedings, but neither do I deny, neither all the industry will accept it as a replacement for physical hearings, because as we all know from experience, the corridors of hearing rooms, the bathrooms, the lunchrooms, the coffee stations are very important places where a feature of arbitration is carried out, and that's the settlement conversations. The conversations that lead to resolution of disputes are often not actually in the proceedings. And for that reason, I hope that physical proceedings will continue. I believe they will, because it's something that arbitration needs. And long may the corridors live.
Long may it
Thank
live
you. Anybody else?
Okay,
I think it is inevitable. It is something that is bound to be embraced by all. It is the new normal. We're going to have to get used to it in every area of our lives. Many of us, I've lost count of how many Zoom meetings I've had and how many Zoom webinars I've attended. And I think that has become a part of the new normal, and it defines it. So I think it's something that it's likely to be embraced. It only requires that we improve or begin to establish protocols, more protocols to make it more efficient and more effective in the process of this work.
Thank you. Thank you. So I'll just hand over to Mrs. Akpata now.
Thank you very much, Kemi and Isaiah. Okay, once again, very quickly, because now we've run out of time, so I'll take an extra minute just to say big thank you to our panelists, to Chukwu Shashere, Senior Advocate of Nigeria, to Elizabeth Ogagos, and Samaya Haridi, and of course, Shaila Ojo. A big thank you to you all. I am certain you have addressed quite a number of the concerns that definitely will come and have already begun to come with virtual hearings. A big thank you to our exceptional moderators, Isaiah Bozimo and Oluwakemi Eweje, and of course, to the SBL team at the back end, Nena and her team. A big thank you. And on behalf of my chairman on the section on business law, Mr. Sheni Adio, who's quite supportive and ever encouraging and definitely has been with us throughout, we say a big thank you to you and to the council for this platform. Like I said earlier, it's the first of a series of webinars, and we hope that as time goes on, we will continue to address any of these challenges that may arise in the area of dispute resolution. So with that, I say big thank you to you all and have a lovely rest of the day, whatever time that is. Thank you. Take care.
Thank
Okay,
you.
Isaiah, that's it. Thank
Bye.
you. Bye-bye. Bye, everyone.
Bye.
Mm-hmm.